Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. I would love to turn over to introducing our expert panelists this afternoon. So going in the order in which they will be presenting their topics, I'd love to begin with Judge James Gray. Judge Gray brings a wealth of experience and dedication to his role as a mediator, arbitrator, and referee. With 25 years as a trial court judge in Orange County, Judge Gray has presided over criminal, civil, probate, juvenile, mental health, and adoption cases, really everything under the sun there. Judge Gray approaches every case with the belief that it's the most important he has ever handled. Known for his meticulous preparation and creative problem solving, he strives to identify the best possible outcomes, understanding that most disputes require practical resolutions. And his commitment extends beyond the mediation session, so he regularly follows up with the parties to ensure lasting results, which really reflects his deep commitment to the people and the families involved. So thank you for joining us today, Judge Gray, to share your knowledge with us. Next, we have Bette Epstein. Bette has been mediating trust and estate disputes since 2000, following a remarkable career first as a licensed psychotherapist and then as a trust and estate litigator for over 30 years. She turned her focus to alternative dispute resolution and brings that unique blend of legal expertise and psychological insight to every case that she handles. Her clients often face situations fraught with grief, family conflict, and high stakes, but Bette's calm, composed demeanor and profound understanding of the law makes her really an invaluable ally in the dispute resolution process. She is available as a mediator, an arbitrator, and a discovery referee. And as a neutral, she brings her unique blend of emotional intelligence and legal intellect and that psychotherapy background to these highly emotional probate disputes. So thank you so much for joining us this afternoon, Bette. And our third speaker this afternoon is Judge Jamoa Moberly. Judge Moberly is a seasoned legal professional who brings over 4 decades of experience to her role as a mediator, arbitrator, and referee. After a successful 20-year career as a litigator and a trial lawyer, followed by a distinguished 21-year tenure as a judge, Judge Moberly has returned to her roots here with alternative dispute resolution, and she's dedicated to helping parties navigate complex legal challenges with a focus on achieving really meaningful resolutions. Judge Moberly believes that mediation is a process that allows parties to reach an enlightened resolution of their disputes through understanding, education, and collaboration. And her approach to mediation is really characterized by her patient persistence and caring attitude, ensuring that everybody feels heard and respected. And she believes that with proper preparation and active participation and patience, almost all mediations can get results in a signed agreement. So thank you so much for joining us today, Judge Moberly. You are all very excellent voices to speak to our topic today, which is preparation for a trust and estate dispute mediation. I will turn it over to Judge Gray, who is going to get us started. And thank you very much.
Well, thank you, Katie. Appreciate the introductions. I don't know if you wrote all of that or not, but that's good. And thank you all for sharing your lunch hour with us. This is a really important subject, and probate, I think, is some of the most heart-wrenching cases that we come across. You have family members suing each other, and as we say, litigation does not tend to bring warm and fuzzy feelings. So to try to resolve the case is critically important and as soon as possible. In fact, I would say that frequently the parents or the deceased have tears in their eyes if they knew that their family members were all suing each other. But we all know also that there's a great deal of preparation for a trial. In fact, you can never be fully prepared. But one thing that is neglected all too often is the actual preparation of your clients. just start by telling what a mediation is, as opposed to what a trial or an arbitration would be. A mediation, of course, is voluntary. So as I tell people in my mediations, you're going to give up your right to hit a home run because the other side will not agree to your hitting a home run. That's just not going to happen. You also give up your right, of course, to strike out because you're not going to agree with that. So we're talking compromise, ground rule double, that sort of thing. So they also need to focus on the words. We're trying to resolve these disputes as opposed to solving them, because there's no solution to most human disputes, certainly including this one. And so you understand that it's artificial and that probably you're going to want, it's my mandate to help you resolve this case today. And it's pretty much the attorney's mandate as well to help you make a business decision. Now, you are the decision maker, you'll tell the client, that you can go to trial for any reason you want to. By thunder, not a penny for tribute. This is a matter that I'd be letting my father deceased down if I weren't to pursue this, whatever. And that's fine, but that's not a business. I want the LA Times to have headlines saying George Smith prevails. I don't think the LA Times would care, I'll tell them, but that's going to be up to you. But that is your decision. But you understand, too, that there's a cost in not resolving this case today. Not only paying your attorney $31 to maybe even $33 an hour for all I know, and that gets some smiles, but also, it takes a lot of energy. It takes a great deal of emotion. And imagine going to trial, telling your story, pouring your heart out, and losing. How would you then feel? So these sorts of things can happen as well. In addition, it's critically important that they understand that what actually happened in your case or in any case is irrelevant. Doesn't make any difference at all. The only thing that matters is what can be proved to have happened, and that's not always the same thing. But if you can't prove it, put it out of your mind is a pretty good watchword. So, for example, there were numbers of discussions that you had with the trustee or with the deceased or with your sister, or whomever it would be. And I can assure you that your sister's recollection will be different than yours. And that so what you want to do is gang up on them, have corroboration. Do you have any emails that were sent after this discussion verifying what it was? Do you have any other witnesses who hopefully are neutral? Let's address those things. If you can't prove it, it isn't going to help you. So you put that out of your mind. Then we go into other things, such as raise issues in the mediation. Raise all the issues you can as soon as you can. What if you forget some, like, oh, Dad promised me the automobile or the grandfather's clock or whatever it would be. If you bring that up at the end, it really sours things. So bring it up at the beginning so that we understand all of the issues to be addressed such that we can then go forward. One problem that always happens is if the client's expectations are unrealistic, it doesn't work for anybody. Even if you get a good settlement, even if you go to trial and get a good resolution, the client is not going to be pleased because she was promised more. And so there's no return business there. There's not going to be any referrals to their friends. Nobody wins if these expectations are too high. Then what about another issue where you want to have the decision maker present? Critically important. If they can't be physically present, Zoom is fine. Zoom works pretty well. If all else fails, have them available by phone. But are you going to need, for example, if you're with a homeowners association or a business dispute, are you going to need to convene a meeting of the board of directors in order to ratify this? If so, tell us at the beginning, but try to have these people available now so that we can get this signed, get it done, and get it over. So you have to have the decision makers be available if at all possible. So those are different things that we're talking about. So at the beginning of my mediations, and everybody's different, you can obviously you have your own proposals. I will tell people that in almost all cases in which we can't negotiate it, and you know what a negotiation is, ma'am. You come out with an opening demand and make it high enough, of course, because it'll only get lower from there, but make it low enough at least to give the other opponents an expectation of optimism that we're going to get somewhere. So if all else fails, though, at the end, I will make, and you can tell them this during preparation, probably your mediator will make a mediator's proposal. I do almost all the time unless there's just a glaring reason not to. And you might want to find out before you have your mediation, whether your mediator issues a mediator's proposal or not. And at that point, I will say, look, this isn't, I'm not a question of doing justice or being fair or trying your case. It's the highest number I can get one person to, the lowest number I can get the other to, or whatever the various other issues are, and try to get this done. Then my procedure would be, and I recommend this to you as well, that if in fact one side says yes and the other side says no, I don't tell the people that said no, the others said yes, and all forget. So you won't harm yourself with regard to future negotiations, because I'll keep this confidential unless each side says yes. Then at that point, we've got ourselves a deal. I try to use, I call them jokes. Some people call them attempts at humor, but I try to lighten the load a little bit. And for example, at the beginning of my mediations, frequently I will tell them, okay, in fact, you heard this a little bit with Judge Moberly. I was a trial court judge. I'm Judge Gray. I expect that my name has been mentioned before, but I was a trial court judge for 25 years here in Orange County. Hard as it is to get my mind around this, I retired 15 years ago last January, but you have to understand, I became a judge when I was 11 years old. That's why I'm still so young, and I don't allow any cross-examination on that whatsoever. Now, what have I accomplished by that? It shows that I've been around, and it also shows that, I'm human, and that, you can tell a few attempts at humor and that sort of thing. And then as time goes on, I'll tell them too, well, you're going to get some money in this case from this estate. Would you like to have a really good investment opportunity? They look at me like I'm crazy, which may be true. And I'll say, well, no, I know you didn't expect to hear a business or investment opportunity from your mediator, but I have such a lead that I cannot keep it to myself. Have you heard that Federal Express and United Parcel Service are actually merging companies? Yeah, it'll be a revolution. And the name of the new company is going to be Fed Up. So they'll go for that sometime. They look in my pocket and say, well, I have some shares right here. I get a really good percentage if you buy some. But it shows then that you can open up. I have no enforcement authority. I'm not here today to argue your case or to make rulings or to be fair. Again, it's artificial. I just preside over these negotiations. So when I'm with you, I will focus on your vulnerabilities. Why? Because it helps me help you see the case realistically. And so, in fact, if I know anything about my reputation, particularly, it's that sometimes I tend to be blunt, but I found over the years that people kind of appreciate hearing it straight shoulder from somebody that's been there, has no vested interest one way or the other. So maybe my bedside manner could be improved, but I tend to be blunt. So I will focus on your vulnerabilities, but cheer up. When I'm with the other side, I'll focus on their vulnerabilities. It'd probably put a smile on your face to hear me talk with them, which of course you will not because it's confidential, but it probably pleased them to hear me talk with you, which of course they also will not because it's confidential. So I see myself almost literally in the dissatisfaction distribution business. I make everybody unhappy with me, but you'll like me a lot more tomorrow when you wake up and know that this case has been resolved, not solved, but resolved. So that's where we are. Let me tell you a secret also in some probate cases. You never quite know, but I will ask the children, for example, in growing up, did you like your uncle? Did you love your uncle? Did you love your brother, your sister, whatever? And if they'll say, well, yeah, I did. Well, do you still? Well, I mean, this isn't much fun, but maybe so. Let me ask you a question. Would you be willing to give your sister a hug right now, just out in our reception area? And then I'll go and talk to the sister and say that as well. It happens maybe 30% of the time that they will. And I'll tell them, I'm not asking you to say anything. I'm not asking you to apologize, anything like that, but just give them a hug. Literally, every time that has happened, the case is settled. It changes the atmosphere enormously. I'll also tell them, look, I understand money is one thing, but my approach here, my goal here is to have you share Thanksgiving dinner with your sister this year. And I think that your parents are applauding that idea as well. So you try to bring the human factor into it. You can also then ask them, well, okay, you loved your sister before. What happened? Frequently in probate matters, and I expect that Ms. Epstein and Judge Moberly will agree with this as well. Frequently, it's been a lack of transparency. Oh, if you knew what I knew, you'd agree with me. No, if you're transparent, if you acknowledge things, if you respond to questions, you're not going to have very much litigation. One way or the other, if there's a problem area, it'll be addressed. It's when people are quiet, then you start getting suspicious and you think, oh, the trustee is raiding the till or they're cheating me or somebody else. So that's something that you need to get into. Otherwise, we get into negotiations, I'm going to ask you to give an opening demand. Have there been any prior negotiations yet? Frequently, it'll say one way or the other in the mediation briefs. And I would also, by the way, frequently I request that the parties exchange briefs. Really helpful for them to see the case from your standpoint and to you see the case from their standpoint. And it really helps me help you if, in fact, you can do that. Take out the poisonous words. Take out, oh, he's a cheater, he's a liar, that sort of stuff. That doesn't help anybody or anything. But if you can do that, and again, if you mention in there what your final position is, you may not want to say that, but just delete that stuff too. But then I would ask you to give an opening demand. I'm going to go backwards now and go to the other side and spread my little charms with them as well. And then I'll come back and we'll see if we can get these negotiations started. But it's really important that my mandate is to help you resolve this case today. And I will frequently start to ask one side, who I think is in a better position legally to start preparing a settlement agreement, a draft of a settlement agreement, so that once we fill in some numbers, but once we reach those agreements, it doesn't take an extra hour to wait while all these things happen. So that's my approach. I'm proud of this. It's so gratifying to help people resolve their disputes, particularly in probate, particularly with family or with neighbors. That's not probate, but it really is a gratification. I'm proud of ADR Services. I'm proud to hang my hat all up there with Miss Epstein and Judge Moberly. And if you have any questions, I'll try to respond. But at this point, I think I've gone through preparation, and now I'm going to look to Miss Epstein. Fire on.
Okay. So, Katie, if you want to put up the slide, you're welcome to do that. So an important aspect of preparation is choosing the right mediator. One of the classic differences is retired judge mediators versus practitioners. And so my particular area is trust, estate, conservatorship, and real property disputes, because that's the area that I worked in as a litigator for almost 30 years. So I bring that experience, that expertise, and that would be true even in other areas, employment or other kind of specialty practices, as opposed to judges who oftentimes, as you heard from both Judge Moberly and Judge Gray, have a very broad breadth of experience in many different kinds of cases. And I think it's important to know your client and who's going to resonate with your client. I think for some clients, it needs to be a retired judge that, despite how many years of experience I or some other practitioners had, they're not going to respect the views and it won't resonate as well with them. Another factor is gender. Who is your client going to be more comfortable with in terms of whether the mediator is a man or a woman? So I think that's something to take into account. And lastly, in thinking about who's going to be the right mediator, to think about the mediation style of the mediator. Generally, mediators are primarily facilitative, where they monitor the process, they encourage communication, they don't necessarily evaluate the strengths and weaknesses of the case. Excuse me. Or the other is a mediator who's evaluative and who learns about the case and will give you their view about the likelihood of success or not. I describe my practice as being facilitative up until about 3:00. And by then I have, really learned more about the case. I've been able to assess credibility, which is often an issue in these cases. Who is the court going to believe or not believe? And if I'm asked my view, I will give some feedback about where I think the strengths and weaknesses are that I see. But in certain situations, when I was litigating, I used an evaluative mediator either to deal with my own client because they were being so unrealistic in terms of their chances of prevailing, or dealing with opposing counsel and opposing client who really need to hear from someone who could, with the right approach, let them know what their case is really about. So that's an important decision. And in addition, I'm also glad to speak to attorneys in advance when they're deciding who should be the mediator, or even with the clients. So I've had calls with parties to mediation who really, this is a new process. Very few of them have any experience with it at all. And they want to hear what my approach is and how I conduct the mediations. And I'm glad to spend the time to have a conversation with them about that. So that's at least an option in making that decision. So next is attorney preparation. So the next slide. One thing that is really critical to a successful mediation is having all of the information that you need to give your client the level of comfort that they want in making what oftentimes are very important decisions, both financially and emotionally. So a lot of what we deal with, as you know, are appraisals. And it's so often that the only information about the value of real property is what people have gotten online from Zillow or Realtor.com or one of those websites that may or may not be truly reflective of the value. So if appraisals are needed, they should be obtained in advance. The other that comes up is tax advice. And oftentimes this relates to both property tax issues and capital gain tax if property is going to be sold. And so I hear that, well, they can't make a decision because they haven't been able to consult with their CPA or their tax advisor. So
Bette,
that.
if I can interrupt for a minute, because the
Mhm.
tax issue is really an important one, and I approach it on the fact that I am really good at two things. Number one, I don't know anything about bankruptcy law, and the other is I don't know anything about tax law. So don't take anything I say as tax advice. You really want to be careful about that, and then move on.
What I can do is I can identify the issues. I can't necessarily solve the problem. So it's really important to have that person available. Next are accountings. In trust administration cases, particularly, accountings are critical to getting the information that you need and the backup data that went into preparing the accountings. That's oftentimes what is missing. And I'm willing to be kind of an informal discovery referee. When I have my pre-mediation calls, I always ask if there's any information that I might be able to get prior to the mediation that would be helpful. And then I'll approach the other side, and oftentimes they're willing to give it to me if I ask for it. And it may be that it's just for my eyes only, or that I can share it, but it will become available because it's really important. Next on my list is the inventory of the tangible personal property, which oftentimes has no financial value at all, but has huge emotional value. And so if there's items that need to be distributed, having an inventory in advance would be very helpful. Medical records are critical to cases in which trust instruments or wills are being challenged on the basis of lack of capacity. And so knowing what the medical records show in terms of any identification of dementia or Alzheimer's is also very important. If real property is going to be sold, then information about potential real estate professionals who might be listing the property for sale or can give opinions as to value. If they don't have formal appraisals, some realtors are very good at doing a market analysis. And then production of records. So again, oftentimes critical information, or at least someone thinks information is critical, is not available. And so if you can identify in advance what's missing, I'm glad to help you try and get that information so that your client is comfortable. In addition to information, the other thing I wanted to mention in thinking about who should attend the mediation, Judge Gray mentioned decision makers, but oftentimes, particularly in these family disputes, people who are not decision makers can be helpful to the process. So it can be a spouse, it can be an adult child, it can be a friend, a neighbor, somebody who the client would like to rely on for support. And my approach to that is that anybody who is not disruptive to the process is welcome. And if they become disruptive, then I'll deal with it. But oftentimes I hear, the other side saying, what? Their spouse is here. They're not a party. It's not their money. They shouldn't be here. And my feeling is that if that's who the party thinks is helpful to them making a binding decision on the day of mediation, then they're welcome to come. So I think that's an important consideration for counsel to think about in terms of who should attend.
Well, Betty, frequently a party won't make a decision until they can go home and talk with their spouse or whomever else. So
Right.
why delay? Just have them there. If they want them for support, bless them.
Well, and I think what's even more important is if the spouse isn't there, they haven't participated in the process. And being part of the process is really helpful in understanding why decisions to get made. I never want people to go home and, say, this is what I did and have them being second guessed. That will not put them in a good position. So I'd rather have them there participating in the process, at least hearing what's going on. So next slide is on attorney preparation, kind of what I would like you to do to give us a better chance of success. First is to be thinking about your problem solver hat, not your heavyweight trial attorney hat, and to be open to creativity. One of the things I do as a mediator is I make suggestions about alternatives for resolution that may not be yes or no, yes, you win, no, you don't win, but something other than that. So to be open to looking at things more creatively in terms of how to resolve the dispute. Second, as Judge Gray mentioned, avoid surprises. It can really create havoc at the end of a long day when all of a sudden there's, well, wait a minute, what about mom's jewelry? Or what about dad's military paraphernalia that we haven't talked about? Identify early on in the process all of the issues that you believe need to be addressed. Because otherwise, I've had even tax issues come up late in the day and spend hours trying to sort that out. So think about all of the issues that you may want to address prior to beginning the mediation. Judge Gray also mentioned the settlement agreement. My instructions ask for one of the lawyers to prepare a draft settlement agreement and share it prior to the mediation. So it would include the recitals, the boilerplate, obviously not terms. And in my pre-mediation calls, I may also remind counsel that I would like someone to draft an agreement. So last week I had a mediation that by 5 o'clock we had reached an agreement. It took 2 hours to get the first draft circulated of the actual settlement document, and then another 2 hours to negotiate the terms and get it finalized. So it was 4 hours of that work that could have been condensed probably to an hour had they actually prepared an agreement. Someone had prepared an agreement and circulated in advance. So it just makes it a much more efficient process. Because my feeling is I'm not a proponent of term sheets. I agree that they can be used on occasion if it's really late in the day and it's a really complicated resolution, to do a term sheet that the parties sign with the understanding that there will be a formal settlement agreement prepared. But to me, that's a last resort. I would much rather spend the time at the mediation getting through the complete document with signatures on the page. So that's my approach. So next, Judge Moberly is going to talk about your mediation brief.
Yes. My part of this presentation is how you can help your mediator. I mean, you've probably paid them quite a bit of money for this mediation, and you really want them to do as well as they possibly can. How do you do that to begin with is the obvious. It's a mediation brief. It's not the same kind of brief as you would submit in court. It's really a framework to help with resolution, to introduce your case to someone who knows nothing about it. And it may be a one-off. You know, this is your one and only opportunity. Be candid. You know, you're an advocate. Mediator understands that. But if you truly want to be in mediation, you need to be a team player. And what should be in the brief? I really appreciate it if the attorney identifies areas that you can agree. And also, I refer to these later when you get into mediation as areas of low-hanging fruit, because it really sets up for a successful mediation, because it shows the parties in mediation that you can agree. So it gives expectation when you hit some of the real stumbling blocks. And then probably more importantly, focus on the areas that are truly in contention and explain why. Are they legal issues? Are they family history issues? Maybe, as has been identified, it might be a tax issue. It truly can be family history. But and lastly, share preferably all of your brief, but at least some of your brief. You know, I'll get briefs that come in and they're marked, you know, rightfully confidential. Then I don't find out until we get into the pre-mediation conference that, yes, that one got shared. And then, of course, find out that the other one didn't. And then it's another step for the mediator to get that to occur. And then this is something I have also in my instructions and expectations, is to have circulation of a template proposed settlement agreement as close as you can get without some of the specific terms. But it really speeds things up. And then often you'll have otherwise in the mediation, one party or one counsel is busy drafting the bones of a settlement agreement. It turns out the other side prefers to do it, and then you've got a duplication of effort. And of course, it can really slow things down.
One other thing I would mention also in what information you provide in the brief, I welcome, I prefer that briefs be shared, but then also am glad to receive a separate document. It's a letter, sometimes a brief, that gives me other information that the party wants me to know that they don't want shared. So I'm glad to have that as well. But I think that sharing briefs is my preference for sure.
And you don't want them to give away tactics. If there's some tactical issue,
right,
keep that to yourself. But exchanging briefs really is helpful. And by the way, I try never to provide the brief to the other side. I always ask the attorney to send it to the opposing counsel, just so it's clear that I haven't breached any confidentiality.
I never do either. I never provide any information.
Yeah, I don't think I've ever done that myself either. And then we're back to the issue about the identification as confidential when it really has not been utilized confidentially. Our next slide.
But Jamoa, it's still confidential for purposes of trial. You know, you can't say, oh, you said such and such. So the confidentiality still applies.
Absolutely. And of course, I mean, this is really the obvious. Maximize your brief, which is to submit it early, not just for the mediator's purpose, but also, as we pointed out, if you're sharing it with the other side. And another reason to share it early is a lot of mediators, myself included, we prefer to wait until we have briefs from both sides before we have our pre-mediation conferences. So it can really delay things. And you may end up with a situation where the mediator has had the pre-mediation conference with the other side, but could not have it with you because they never got a brief. And then probably the most frustrating situation for a mediator is to finally get a brief at 10 o'clock the night before the mediation. It's obviously a lot of work put into it. Would have been great to have had it. May have a lot of exhibits attached to it. And, you know, I do my best to read it thoroughly, but it's really at a disadvantage. So if you're going to put the work into it, please submit it early. And that brings us to the pre-mediation conference, which is my next slide. And this really is a first introduction. It's to make everyone more comfortable before the mediation begins. And it's to focus on what I refer to as soft issues. It's not a rehash of what's in the brief. You assume the mediator has read it thoroughly. It's to go over items like, you know, your client expectation, problems you might be having with your client, opposing counsel discord. Not everyone wants to put it in their brief, and hopefully they don't put too much of this in there. Problems they are having with the other side. And then your smoking gun. You can identify whether you have one. Mediator has a chance to discuss with you if it's really that smoky and whether it's going to be that powerful at trial. Preference usually is to share it in the mediation. And again, under that cloak of confidentiality. So it really gives you that chance. It also gives the mediator a chance to discuss with you who should be in attendance and whether or not they have any objections. You know, frankly, I've run into situations where someone appears in person, they're down the hall, and it's a real problem if the other parties know that this person is in the other room. So it minimizes some of that discomfort.
Jamoa, I feel so strongly about pre-mediation conferences. It's a telephone call. And I would recommend that a counsel initiate that if they would like to have one. They have some information that they'd like the mediator to know. There's no ex parte communication problem here. So I would recommend to counsel to try to contact me or your mediator and to set up that call.
That's right. And that's the issue with the scheduling, because I routinely call counsel to set that up. But, all the mediators have a different procedure. Some go through their case manager. And don't be shy. If you truly want to make sure you have that on calendar and you've got a real busy mediator, ask the case manager to get it on the calendar.
Mm-hmm.
It's included usually within, what you're paying the mediator. It doesn't cost you extra money. And I think most mediators are also conscious of the fees to the client potentially and having those calls. Also, try to be available because oftentimes the mediator will need to have this conference at night or during the weekend. But it's to everyone's benefit. And
one of the things that I just wanted to mention, one of the things that I think it can be very important when I have these pre-mediation conferences is asking counsel, what can I do to help you? What we know is that, particularly in these trust and estate disputes with unrealistic, highly emotional family members, counsel is really being challenged to help them appreciate that there really is nothing like a slam dunk case, as much as the client thinks they have one. And so I will ask counsel what assistance I may be able to provide them in helping their client make a business-like decision that will resolve the dispute. And I oftentimes get good information. So that's one of my key questions that I always want to know, as well as what information still might be obtained that would assist the client in feeling a level of comfort that they are well advised in terms of knowing all the information that might be available.
Sure, Bette. And the issue of client control is huge because you can't talk about that with your client, with the client present, but you certainly can. And then we can address those things, but I can't address it unless I'm familiar with it. So good move.
And just one of the things I also do is during the mediation, and it particularly works well with Zoom, is in my introductory remarks, I tell each side that oftentimes I will want to speak with counsel separately. And when I can see that counsel's having a rough time, I will ask to speak to them and I'll move them into another room so that we can have a little chat about what might be helpful to get their client to the point of being more realistic about what the outcome could be.
Sure.
So, or if I'm in person, I'll just invite them into a different room. So that can be helpful as well. But I definitely ask that question in my pre-mediation calls.
Jamoa, how often do you have a joint session in your mediations? And I almost never do.
Rare.
Very rare. Right. I have it if they need to meet with a third party. For instance, if there's going to be, for instance, a successor trustee who's a professional fiduciary and they're deciding on who that might be, to meet with them, either a conference call if we're in person generally or on Zoom, or a real estate professional who's going to be potentially listing real property. So I only do them if there's a third party involved and it's just more efficient to have them all meet together. Otherwise, I almost never have a joint session.
But you can have a meeting between you and the attorneys on each side. And frequently I found that is quite helpful.
Yeah, it can be very helpful. And I do that also when they're trying to get the settlement agreement finalized. Rather, me being in the middle of that conversation, if we're on Zoom, put the agreement on screen share, let everybody see it, and make changes in real time. And it just is a much more efficient process.
Yeah, instead of going back and forth forever,
right.
You're absolutely right.
Right. So I think those are our words of wisdom here.
Well, I'd like to go back a couple of issues because you raised them. Jamoa, I hadn't focused on this particularly, but yes, focusing on the small issues to start getting attraction of, okay, we settled that, so now I know they'll agree, and I know now we can go to the more difficult issues. It really is quite effective and good for you. You also want to ask them for options. If you've got a business case, maybe the supplier and the merchant can work together in the future and have better deals for the supplier, or that sort of thing, or what options I'll give you. You can get the automobile if I can get the grandfather's clock, or whatever. But raise them, and don't have them premature, and don't tell them your options too prematurely. But engage them in, hey, what's another, instead of just money, instead of whatever, what other options do we have? Maybe you can get the season baseball tickets. I mean, who knows? But those things are important. Another is that if you're selling a property, selling a real property, it's very helpful to have the various people paid through escrow, not through the trustee, but just have escrow instructions. And okay, once this is done, 20% of the net will go to client A, or that sort of thing. But use the escrow officer, really quite effective, and the rest. I have one final comment, if I may, that maybe you can see these stacks of papers behind me, but I follow up on my cases. I had a little extra time this morning because my arbitration went away. So I follow up. And sometimes it's been a couple of years, but I'm still successful probably 40, 50% of the time in bringing an ultimate resolution. And it's a service. I don't charge for my time on the phone. And I also tell them, if in fact we're breaking up now, I'll tell them I will give you what I lovingly call pester calls, maybe every 4 or 5 weeks, to see if there's been any change, any attitudinal change. And if you have discovery disputes, what I'm asking you is have a meaningful meet and confer with other counsel, but then before you start filing motions to compel, get me on a telephone conference call, and I'll see if voluntarily we can resolve it. And I'm successful maybe 30% of the time there, but think of the amount of money and emotion and time is saved. So it's all a service, and I don't charge for my time on the phone. It's just we're in the service business, and I find that that's one way we can show that.
Right. And I do follow up. I try and follow cases online when they haven't settled. And so some of at least the Bay Area counties have really good websites where you can see exactly what's going on. And so I check in periodically to see if there's any new development. And when I see that now they have a trial date, I oftentimes will say, okay, I see you have a trial date. Before you spend the time and the money to prepare for that, is there anything to talk about? And I think even if there isn't, lawyers appreciate it. So
Bette, I am not a techie at all. How would I check? How would I follow through on the internet to find if Smith versus Jones had settled or had a trial date?
It's real easy. If you have a case number and you can go to the Orange County Court website, it's very simple. Some websites have better information. Some you can get documents, you can't.
I'll probably still have to call you with this particular case, but I'll try that. Thank you.
Call me. I'll get the information. And I do
want to hop in with some questions.
Yeah, I see
here.
we have questions here.
We do. So one of our questions pertaining to the pre-mediation call, do you usually do that just with one side? Do you do it with both attorneys together? Do you have clients present? What's the structure of that usually?
I do it individually.
Right, with each attorney separately.
Just with the attorneys, yes.
Right.
Yeah.
Mm-hmm.
Yeah. But it's quite a service. It's frequently quite helpful. It gives us a lot of insights into what's going on, and we can also plant a few seeds in the minds of the attorneys too. It's a useful thing to do.
Right.
Mm-hmm. One that's particularly pertinent, I think, to trust and estate disputes. What would be pros and cons for in-person versus Zoom or even a hybrid mediation in your practices? What have you seen?
I think Zoom is really effective. And that initially the concern was people wouldn't be engaged. They wouldn't really be committed to doing the work to get the case resolved. I don't find that to be true. I think that when they're on that camera and I'm in and out of the rooms constantly during the day, that they're engaged. And for me, frankly, in terms of meeting with counsel, it's much easier on Zoom than trying to find another conference room in the office and moving people aside. And documents can get signed through DocuSign. So I find that there are certain instances when I think meeting in person is appropriate, particularly if it's a very elderly person who's not going to be able to really relate to looking at you on a screen or hearing from you on a screen. But I've also done Zoom with people in their 90s, so it's not necessarily age. But and some lawyers think that that's the only way the case is going to resolve. And I'm glad to accommodate them and to meet in person. But I think Zoom is a very effective way of managing the mediation
Yeah,
process.
Bette, I agree. I was very pleased when I had COVID, and I was leery of doing this, but I don't think I had a case where I thought if they'd been in person, we would have settled it, but we didn't. It's very, plus, I think my chances ever again of seeing an insurance adjuster in person from Omaha are gone. It's just, it works. It works. I'm pleased to do it.
Right. And in these cases, beneficiaries oftentimes live all over the country, or they live in out of the country.
I had a mediation 2 weeks ago with a party that was in mainland China.
Yeah.
Kind of a different time zone, but yeah, try that one in person.
And so the cost saving is really significant for people that don't have to fly cross country, stay in a hotel, or make other arrangements. And so they're glad to be able to participate in a meaningful way and not incur that time and expense.
Yeah, I can see with the beneficiaries appearing hybrid wise by, I do see some problems when you have a hybrid and one of the parties is local and they're on Zoom, and you've got the person who came from relatively far away and they're in person. So you have to look at that imbalance sometimes.
Right, right.
Since we are talking about preparation, I'd imagine that there's different preparation that goes into preparing a client for an in-person mediation versus preparing a client for like a Zoom mediation. Do you have any suggestions for how attorneys can prepare their clients for the day of mediation on either platform?
Well, one thing to help them appreciate that it's going to be a long day. I mean, mediations can go very long and into the evening, particularly when you have a settlement that you're trying to document. So for in-person, we used to tell people, I know when I was litigating, I'd say, bring a book, bring a deck of cards, bring a jigsaw puzzle, something, because you're going to be sitting around and waiting.
Plus, I found it's really difficult to serve lunch to people if they're on Zoom.
That's true. And you actually do have to think about that with Zoom to identify when they're going to be free to go off to do their walks or.
Right. But I think that it's just very effective, and I think it's here to stay. I hope it's here to stay.
Katie, there's a question about whether a mediator should share their opinion about the merits of a party's position. And I will do that. I will listen, make sure I understand, and then tell them, you don't want to be in my courtroom with regard to that issue because I would not find in your favor. But fortunately, of course, I'm not going to be your judge. You have a jury. I won't be on your jury. But I'm concerned about that issue. And if you lose that one, it's really going to harm your overall standing. So I'm blunt about it. I try to be, graceful, but I think you're not doing them any service at all if you don't challenge them on certain things.
Yeah, I do it sometimes by asking questions. Like, I'm not finding evidence to support this theory. Is there something that I don't know? And it's a way of conveying the message without saying, I don't think you are going to be able to prove that element of your case.
And that's valid too. We do not want to be seen as coming between an attorney and the attorney's client. That we just cannot do that. You might take the attorney aside and then you can talk, but that's to be avoided at all times.
Right. I've taken an attorney aside, for instance, if credibility is a question, and I've taken an attorney aside and said, do you think you're going to be comfortable having your client testify? And that's the message, is that your client's not going to be effective. if you're relying on that testimony to prove your case.
Or I will ask the attorney, hey, did you take the opposing party's deposition? Yes. What kind of a witness did she make?
Right.
And they'll tell it, well, she was pretty straightforward, whatever. But that is, it's neutral, but because it's their decision. But they'll be pretty realistic about that.
Right. So I see
it's fun, isn't it? It's challenging. There's nothing as gratifying as helping people resolve. I give myself much too much credit when the case is resolved, and I kick myself around much too much when they don't. But it's a great business to be in. I'm proud of it.
It is.
We have one more that's pretty pertinent to a lot of your practices around kind of client control and client incompetence. So what's your practice when you are advised that one of the parties is perhaps incompetent or being controlled by another person, like one of their adult children?
That oftentimes is an issue that gets raised, that they're being unduly influenced. Hopefully they've got counsel. Sometimes I'll ask the question in a pre-mediation call if someone should have a guardian ad litem, if they really have been deemed incapacitated, that is someone there to protect their interest. There are times when it's certainly questionable, but you hope that the lawyer is doing their job and that they have good representation to make sure that their interests are protected.
Yes, well, it is unethical for an attorney, for example, to draft a will or a trust for someone that they believe is not clear that they're competent. But once they do that and then they sign it, now, of course, you're going to have that attorney testify in the future, and boy, that's rock solid. They've already committed themselves. But it's critically important. I think it's important for mediators as well, that if I don't think you really understand what's going on, I've had this happen once where I said, go and think about this and talk to a counselor or something, because I would not let them sign the agreement because I just didn't think that they understood. They were being pressured, whatever. We're still in the mediation business of and truthfulness. There's another question, Katie, which I have not encountered, but for successful financial elder abuse cases, have you seen fees be awarded with a multiplier? And do you use fees and multipliers, that is leverage, in your mediations? You understand, of course, in cases of that kind, there can be at trial multipliers or whatever. There can be punitive damage. I mean, there can be all kinds of things, but I don't use them in my mediations except just to tell them that that's out there. And it's just another fact of life.
Attorneys' fees are often a topic of conversation about how they're going to get paid. And
you're so crass, Bette. You're so crass. My goodness, such cynicism.
But it's often a big sticking point, that attorneys want to be paid out of the trust, typically, or out of the estate, and what their fees are and whether they're reasonable and whether they should be paid.
Or out of escrow, if it comes to that.
Out of escrow, right.
So, Katie, I have a question for you. I've used this in my mediations. What do you call a cow that's just given birth? What do you call a cow that's just given birth? And I had an attorney off the top of his head one time say, utterly exhausted, which I thought was really pretty good. And another attorney said moother, which I also thought was pretty good, but I like mine better, Katie. What do you call a cow that's just given birth? And the answer is decaffeinated. Then I tell people, I call them jokes, you call them attempts at humor, but there's a method behind this that it encourages people to settle their cases more quickly so they don't have to keep hearing more of them. And they're usually pretty effective.
Well, with that, we are at our 1 o'clock marker here. So I do want to wrap up for the afternoon with my many thanks to you, our panel of speakers, and Judge Gray, our resident comedian. Everybody, as you leave the webinar, you will be directed to a brief survey. We would really appreciate if you take a couple of minutes to respond to that. Let us know any feedback for our speakers, and ideas for future programs. We are always soliciting ideas for future MCLE programs. We'd love to give you things that you're interested in learning about. And once again, our part 2, focused on the mediation session of trust and estate disputes, is going to be October the 2nd. You can find registration for that on our website. We will also send it out with your certificates, which will be coming via email within the next week. So thank you so much to all of our speakers.
Katie, I have a few minutes to answer some questions if we can stay on, if people want answers to questions. Do you want me to go through them? Or
Wonderful. Thank you. Yes, go ahead. And anybody who has to head out, you will MCLE credit, but thank you, Betty. That was wonderful.
So I have a few minutes because some of them are easy. So a question is, what's a term sheet? Because I referenced a term sheet. And sometimes it's called a term sheet or a memorandum of understanding, where it's basically just the terms of the agreement. None of the recitals, none of the boilerplate, but just the actual terms of the agreement so that they're memorialized. And then that can be turned into a complete settlement agreement. So that's what a term sheet is.
It's enforceable, though.
Yeah. And so the parties sign it. And
let me tell you one other thing on that, because there was actually one time, maybe 10 years ago, where I had a case, it settled, and then someone claimed that somebody exchanged a page in the settlement agreement. So now if I have everybody that signs initial each page at the bottom and then sign. I recommend that to you. It also shows that at least they're familiar with each page.
Right. That's a good idea. The next question about exhibits limited or summarized like depot quotes. I don't need 50 pages of a depot transcript if the only thing that you really want me to read are 2 pages. Just give me the 2 pages or pull it out. I don't need extra paper. So that's the answer. That's my approach. My guess is that for Judge Moberly and Gray, it's similar.
We do want the exhibits limited, but if you have voluminous ones, just highlight what part we're to go look.
Right. Also, I ask in my introductory letter is that if it's more than 20 pages, to have a hard copy sent to me, because I ask that it also be 3-hole punch, because I put everything into a binder. So I've gotten hundreds of pages that then I have to 3-hole punch, which I would prefer not to have to do. But anyway, those are my instructions.
You have a question there too. When is it fair during the mediation to ask the mediator to evaluate the case? I think that's always fair.
Right.
We'll start out by saying, I haven't seen the witnesses and I haven't, but this is my impression. My impression is that you're a good person, or my impression is that you're having a little bit of trouble remembering. Whatever it is, I'll be accurate. I don't always say everything I'm thinking, but when I say something, it is the truth.
And it may be that at that point, depending on where you are in the course of the day, is that you still have questions that could be addressed that would help in the evaluation. But I do think it's fair. My preference is to not be evaluative until later in the day, because facts develop, witnesses develop during the first number of hours. And so that's generally my preference. Are there other questions we haven't addressed?
Katie, ask any cook. A boiled egg is hard to beat. With that, I think we've answered all the questions.
I think so.
Yes, I don't have a checklist about what to cover in a pre-mediation conference.
No, I don't either.
Nor do I.
It's organic, actually.
There's a good question about when some parties are self-represented. And yes, if you need them to be involved to reach an agreement, then you've got unrepresented parties.
And you put in the agreement that they were not represented, that they were told that they should get counsel, but that we do not represent them. We do not give them legal advice.
There's also an ADR services form that explains that all unrepresented parties are asked to sign, which confirms their understanding that we're not giving them legal advice, that we're not their counsel, and we're not giving them legal advice. So it's a form that they're asked to sign in addition to the confidentiality form. And in terms of who needs to be there, absolutely. You want everybody present who's necessary to do a deal, to get the agreement done. So those are questions in the pre-mediation conference. After you've read the briefs, hopefully you can identify who all the necessary parties are, and you can make sure that they're available. And if they're not available, for instance, on the Zoom call, that they're available by phone, so that you can talk to them during the course of the day. So I try and be flexible in terms of making arrangements that everybody can live with in terms of being available, and being part of the process. There's a question about an independent review.
I'm independent.
Yeah.
But that's, if they want to get an expert or get somebody else, go for it.
Yeah. Well, I think they're asking about if there's a potential conflict in the estate plan. I think that's what they're referring to, and whether there's an independent review. And yeah, I mean, I think one of the always questions is how much time they spent with the person, what documents they had available to them. There's a whole analysis, just like you would do with the estate planner.
Well, now you're just trying the case.
Right.
And their qualifications, of course, are relevant.
Sure.
Right.
Can a term sheet be enforced if only agreed to via email, especially when the acceptance of the proposal was qualified with an understanding? You're getting into treacherous territory there.
Right.
It should be signed in some fashion. I even have them initial if possible. There is case law as to whether when you send an email, but I'd research it. I hesitate to go any further on that. It's critically important. If close, don't do it.
Right.
Oh dear, there's a question suggesting kids be co-trustees. I do not recommend.
Kids under 18?
No.
They can't even be parties. They have to have a guardian ad litem.
Adult kids. I think it depends on the relationship.
Yeah.
I think sometimes estate planners don't ask the right questions. And if the document has a co-trustees like, do you share the holidays together? Can you all sit around the Thanksgiving table and have a good time and enjoy each other's company? When you find out that, one of the co-trustees hasn't been involved with the family in the last 10 years, nobody speaks to them, and now they're expected to work together and make business decisions. I think it's risky.
It's not going to happen.
I think it's really, I mean, we know co-trustees can work cooperatively. We don't see them in our practices. We know they're out there, but I think you have to ask the right questions to make sure that these adult children are prepared to work together and make decisions together.
I was the trustee for each of my parents when they died and two of my uncles, and I had no problems at all. Every month I would just send out informal notifications. Hey, this is what's in the estate right now. This is what came in this past month. That's what went out and to what. And I didn't have any problems with anybody. Most of the problems, I think, are lack of transparency.
Right. Yeah. Absolutely.
Overdo it.
Right. Yeah.
Katie, I think we've eaten it. We've done this. So, Katie,
yeah, we're about to time here.
I'll ask one final question. Do you know the difference, Jamoa, between a dad joke and a bad joke? Well, one is apparent.
Good.
Bye.
Bye-bye.
Thank you.
Bye-bye. Thank you.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront. Woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.